There we go. Good morning, Don.
But oh, that's right. The other one's already on. I'm still looking for how do we start the broadcast? We're already broadcasting. Good morning. This is Financial and Estate Literacy. It's Your Estate, fall of 2022. We're talking about wills and trusts today. I want to just do a very quick little overview in terms of a couple of pieces. One is the website that you can go to is here. It's also on the announcement you get each week and an hour before the presentation. It's that same location that you have. There's a workbook that we had done a while back. Left alone in a dark room, I'll write something, I guess. And I had done 3 workbooks. They happen to be there also. And if Pete wishes, in a moment, we can go through and look at the website. And just as one quick note, we're doing wills and trusts. Next week, we're doing retirement planning. And I just want to give you a heads up. On the 20th, there will not be a broadcast. We will not be here for that particular one. And Pete, do you want to go to go to the website?
No, let's go right into the program. And we'll, Jim, Mr. Leese, why don't you come on board? And what we're going to do is that we're going to introduce Jim. Jim's Ask First form is on our website, IYME. But I'm going to just do it orally because one of the things, you don't have to, everybody knows it's there, Jim. Let's just have our faces on the screen. And since I've known you for over 40 years, we can just talk. How long have you been in practice?
Longer than I can imagine, Pete. I was accepted into the bar in 1978.
So you're an old man. Talk a little bit about your firm.
I joined Ferruzzo and Ferruzzo, which is a pretty well-known law firm here in Orange County. I joined it in 1987. It began in 1980, and we basically have grown it from 4 attorneys, myself including in that 4, to 26 attorneys. We've expanded our practice from not only estate planning, which we're going to talk about today, but also into estate litigation, probate litigation, mergers and acquisitions. We represent maybe at one point in time 60 auto dealers in the area. So we have a big emphasis on auto dealerships, both buying and selling and formation, and for that matter, operations on the transaction side, but also in the litigation side. So our firm has 5 major groups, one of which is my group, which is the estate planning.
And how many attorneys do you have there?
26 attorneys currently.
No, I mean,
in my group,
yeah.
9 attorneys. Yeah.
So, and you exclusively focus in on the estate planning area.
Yeah, I've been able to focus in on what would otherwise be called both fundamental and advanced estate planning.
Yeah. One of the things I love about your firm, Jim, is that you handle cases from $50,000 to $1 to $2 billion, right, and everything in between.
Correct.
And not only that, but you're not a national firm, you're a local firm. So you don't have offices nationwide. You really focus in here in the Orange County area.
That is correct.
And so I am going to ask you the question of the week, and that is, how do you charge your clients?
Well, we charge typically on a flat fee basis for what we call fundamental estate planning. With advanced planning, you can't do that because there's a heck of a lot more conversations, a lot more conferences, a lot more due diligence necessary to reduce estate taxes and make sure that our asset protection planning is going to be correctly done.
And so give us the range of your hourly rates. What's the lowest hourly rate for your attorneys, and what is your rate? Because I'm assuming you're the old guy and you're the top dog. What's your rate now?
You keep calling me old, Pete. There's no problem. Bottom line is we've got young associates are at $350 an hour, and that's really low for Orange County. And then we are also at my particular rate currently is $595 an hour.
Okay, and then for a typical estate plan on a flat fee basis, we're talking one property, a retirement account, some investable assets, 1 or 2 kids, married. What's the approximate flat fee cost for that for a married couple?
Currently, it's around $3,800 for that couple.
Okay.
and
And then as far as, do you provide a free consult at the beginning just to get somebody an idea as to what it's going to cost them?
For those people who come through this particular presentation, we waive our initial consultation fee. Basically, it's $300, but we would waive that for your people.
My people, I love that. I've never had my people.
Pete, we all know that you rule the world, so
Yeah. Okay. Jim and I go back many years, and he's just a wonderful legal counsel, and he's also and he's basically, I think, developed his law firm to look at the family issues. Because, we're all vulnerable one way or another. And so it's not just about the taxes and the monies. It's also about really getting to understand the family situation. Jim, let's go get your outline up on the screen and let's go through it.
So can you see that, Pete?
Yeah, looks great.
Again,
I like the word senior on there, Most people try to avoid that.
Well, I earned it, Pete.
Yeah, you did.
That's the key.
Just for, sometimes we don't get to know our presenters personally, but one of the things that if any of you have a special needs child out there, Jim has a son named Dylan who is has a special need, and so he's particularly sensitive to those issues. So if anyone out there has a special needs child, I would recommend Jim highly. Jim, let's get into it.
All right, so as you'll see here, this is my contact information on the front page. So if any of you want to contact us and tell us that you came to us by virtue of this particular presentation or any of Pete's presentations, be glad to help you out. Let's go down. This is my curriculum, and I've been doing this for many years, as Pete knows. I've taught and I've been a master's in tax and all of those wonderful little issues that may fit on my tombstone, but I'm not sure.
Jim,
yeah.
Click on the screen. You've got a pop-up box in the middle of this.
Okay.
Yeah, there you go.
There you go.
So Pepperdine, bar
certified specialist, a master's. You are absolutely qualified.
All right. Well, and then for some reason they gave me a super lawyer designation a long time ago, and I don't wear the suit, so that's the good news.
Good.
So what we're talking about today, and what Pete has asked me to go through, and I'm sure Pete has some things to interject as we go through here, because this is a really wonderful opportunity for me to get together with Pete, because otherwise he won't accept my reservations for lunch. So essentially, in the basic estate plan, what is a basic estate plan? Well, in the olden days, and that was prior to the appreciation of real estate in California, we would basically rely upon a will. But in California, as you're going to see, it's antiquated. We're now using trusts. So basic estate planning would include a trust, which we'll describe, a will, which we call a pour-over will. We also talk about things you've already discussed perhaps in other forums, and that's the Advanced Healthcare Directive, the Durable Power of Attorney, a personal property memorandum, and then all kinds of titling documents, especially deeds and assignments of corporations, of partnerships, and other business interests maybe that you have, as well as instructions on how to transfer assets into the trust, which we're about to describe. What is the personal property memorandum? Well, bottom line is you may have a lot of stuff. That's what we call it. It's tangible personal property. Tangible personal property is everything, including furniture, fixtures, art, collectibles, heirlooms. Now, I'll tell you, in my practice, oftentimes the biggest source of consternation and confusion and fighting has to do with stuff. And we've basically had situations where our clients have gotten into litigation over such things as a yellow couch, over a sewing machine, and over a 57 Thunderbird. Now, as Pete will know, I will fight over the 57 Thunderbird. but bottom line is, you as the consumer probably, as Pete mentioned earlier, want your children to have a relationship after you die. And if you don't be specific as to who's going to get what with regard to this memorandum, it's highly likely in certain percentages, even if it's small, that there won't be a relationship going forward if somebody takes the yellow couch or the sewing machine or the 57 Thunderbird and the other one wants it.
Yeah, because there's a lot of emotion attached to these things. And therefore, you could have a $5 million estate, and for an heirloom that has a lot of emotion, people get very nasty over those things. Personal property memorandum is an absolutely great idea.
And typically what we do is we don't have that within the definitive documents. We have the individual client write out a list of items that go to certain individuals. So you have the individual and what that individual is going to receive. And I kid my clients when they're preparing these documents that if you get angry at any particular individual, you simply just tear up the memorandum and do a new memorandum. And if you really want to make an effort of making your point, you tear it up in front of them. That's basically the plan that we do.
Do you do an assignment, Jim, in addition to the memorandum?
And so, yes, your will, which is basically your pour-over will, could be the provision of the estate plan that causes the tangible personal property to be distributed. However, we don't rely on that because we don't like probate. So what we're going to do is basically have you sign an assignment of personal property to the trust, assuming you're going to have a trust. And I recommend everybody consider having a trust. That's a way to handle that problem.
Yeah. And should the trustee be the controller as to how you distribute based on that memorandum?
So I think that's a loaded question. The answer is it depends. The one thing we do learn in law school is there's never a yes or no. It's always a depends.
Everybody's learned that in the workshop series.
So it depends on who you're naming as the trustee.
Yeah.
I mean, to some degree, power in the hands of the wrong person corrupts. Absolutely. Somebody said that once.
Yeah.
And so essentially what we're saying is that, yes, you want the trustee to do that. However, you want the right person in that position to act as trustee. Otherwise, power can corrupt.
Yeah. Let's go to the next slide.
Yeah. The durable.
By the way, Jim.
Yes.
I would like you to skip over this slide since we went over it last week and we went through the Advanced Healthcare Directive last week. Let's get right into the will and trust. Thank you.
You're very welcome. So here's what we have. A will versus a trust. A will, as you can see in the slide, says a will dictates where your property is going to go when you die. It requires administration. And that's what we call the 4-letter word that begins with probate. It's actually a 5-letter word, but it begins with something that's not fun and it's bad. So we're going to try to avoid that as much as possible in your plan, especially if you have assets greater than $185,000, because that's the basically ceiling amount that would require probate. It costs time and money. For $1 million estate, for example, we're not looking at the net value. So you could own a home in Laguna Beach if you can find one for $1 million, and you could have a debt against that home for $990,000. And in essence, they're going to charge a fee for the attorney and the executor equal to the $1 million, not the $100,000 delta difference. So essentially, it costs time and money, time being 12 to 24 months on an average, somewhere in between there, to go through a probate court. And I tell clients when I'm going through this process that, have you ever been on the freeway in Southern California? If you have, then you know that only maybe 25% of those people have ever thought about estate planning. And to those that don't think about estate planning, they don't have a will or a trust, and they're going to basically die. And when they die, it's going to go through probate if it's over $185,000. Now, if it's under $185,000, there's other methods by which you can avoid probate. However, if it's over $185,000, and again, it's not net, it's gross, you're in a position where you have to go through that very expensive, very time-consuming process to get your assets to your loved ones.
And when you say going through probate, how does that relate to title?
So I die. If I own something and I die, it's got to be transferred out of my name to someone else. But by virtue of the fact that I can't sign my name after I die, and I tell my clients, don't go home and try that. If I die, then somebody has to be appointed by the court. That person typically is called an executor if there's a will, or something called an administrator if a person doesn't have a will. What's not known commonly is that if you don't have a will, you in fact do have a will. It's basically interpreted and it's governed by the probate code, which says that there's an intestate succession. And we won't go into the specifics of that, but the reality is that the will and intestate succession is only necessary when you have assets more than $185,000 in gross value and you can't sign your name.
In your own personal name. So there's a probate estate, and a probate estate means that you have stuff that are titled in your own name.
Correct.
And are we going to go through joint tenancy, tenants in common here, or do you have a future slide on that?
Yeah, let's go through that.
Okay.
And then typically a will waive something called a bond, whereas in intestate succession, if you don't have a will, you don't have a trust, and you have assets that don't pass otherwise, as we're going to talk about, there's basically a bond that's required of your representative. In a will, you basically are going to have an estate tax consequence potentially, but most people aren't going to rise, if you will, to the level of estate value that's going to cause an estate plan that results in any estate taxes. But we'll talk about that as we go through there as well. A trust, on the other hand, is designed to avoid everything that a will would require. So in a trust, it does still dictate where your property is going to pass when you pass away. It requires administration, but it's not through probate. And that's why we're trying to basically use a trust as what's called a will substitute. So it is the one basically that avoids the court systems, but there's administration necessary to pass the assets following death. But it's a private administration. It's not a public one. So instead of going through a probate court, which is totally public, everything's open to the public. It's a private administration done in an office with an attorney and a CPA and the trustee to make sure that everything goes and passes properly. It does cost time and money, but generally speaking, it's less time and money. And I generally speaking say it's going to be anywhere from $5,000 to maybe $10,000, potentially $15,000 or more if you have a significant estate, but it's still going to cost money. But mind you, if you're in probate and you're basically having to pay probate fees on $1 million, it's going to cost around $50,000, $25,000 for the estate attorney, and $25,000 for the quote executor or personal representative.
And when you have assets in trust, it's also a way to hold title to your assets.
Yeah, we'll talk about that as we go through. Typically, it does not require a bond. We want to avoid costs associated with planning, and that's one way to do it, is to have a trust. And then again, depending on the size of the estate, a trust will also give us the opportunity to at least do more planning to reduce, if not avoid, estate planning, estate taxes. A will is public, a trust is not. The will governs property in your name. A trust basically has trust property in it. And the idea here is you're transferring it from your name as the owner to yourself as trustee during your lifetime. So there's really several different periods of time or chapters of the trust document that we're going to describe when we get there. Beneficiaries are going to receive property at age 18 if you have a will and you haven't otherwise provided it. Whereas in a trust, we can literally name the age or leave the property in trust for the benefit of the beneficiaries for a very long period of time. And we'll talk about how that is going on as we go through. In a will, we have to go to court, whereas in a trust, we're outside the court's purview. And as a result, that saves time, a significant amount of time. Because I don't know if you know it, when you go to court, you get a date. And generally these days, it's not soon. It's
no, it just, I'll give you an example. We just filed a petition with the court, and just to have a date, they're estimating 2 to 3 months. And once you have a date, they're estimating now that 6 to 9 months out. So it's because of COVID, and we're a large county, and there's a turnover of judges in the Orange County court system. It's taken a lot longer than normal, and it was long to begin with.
It is. So that backlog, especially after COVID, has become untenable for most people. And what Pete's saying is you're waiting for the court to basically decide on an issue to move forward, which means that you're basically in limbo until such time as the court decides whether to move forward or not.
Yeah. And by the way, the trust is not instantaneous. I mean, it takes 6 to 9 months for most trust administrations to be completed.
Oh, that's correct. And so we're going to go through what if you do nothing. If you don't plan, basically your heirs, whoever they might be, are going to receive the benefit. So again, who are your heirs? Well, it's really going to depend on whether you have children. Typically, there's something called the line of consanguinity. And the line of consanguinity is a real long chart that says that if I die, it goes to my children if living, if not living, to my grandchildren. And then if there's nobody in that line, then it goes up to my parents if living, which they aren't, and then goes down to my siblings if living, and then to my nephews and nieces, and then into generational lines down. If there's nobody in that line, then it goes to uncles and aunts, cousins, and it keeps going until they find somebody who's alive to receive that interest.
Yeah. It does not get skewed to the state. Most people think that the inheritance, if you can't find the immediate family, that it goes to the state of California, and that's not true. Does California have a inheritance tax or any kind of rules governing this estate planning mechanism? So
there's 2 lanes of the highway. I like to think of the 405 freeway whenever I'm thinking about estate planning. And there's several different sections of the freeway that are defining what we're doing here. The first lane of the highway is called the transfer lane, Right now, all we're talking about is really how property gets transferred. The next lane over is how property gets taxed. So when we're talking about transfer, we're saying, okay, if you have a will, it goes through probate. If you have a trust and it's funded, which we're going to talk about, basically it doesn't go through probate. So that's the transfer lane. Now, bottom line is if you have a will or a trust, you're still having to consider what's the tax ramifications of dying. And essentially what happens is there's something called a federal estate tax. I have to say that quickly, estate tax. So not state tax, it's an estate tax. It's at the federal level. The state of California does not have an inheritance tax. And I can go on and on and on historically as to why that is, but in 1982, it just went away. All right. So essentially what we're just talking about for California is that there is going to be potentially an estate tax. We'll talk about specifically what that is, but as a precursor, right now, I could die, and if I have less than $12,920,000, there won't be an estate tax. Now in 2026, that's probably going to go down too because of something called the Reconciliation Act under federal law that's going to make it go back to what was 5 million plus cost of living, which generally speaking, we think is going to be around $7.5 million can pass tax-free. Yeah. So as you can see, many folks out there will not have estates large enough, even under the Reconciliation Act 7.5, to cause any problems with regard to taxation.
And if you have property and you just have a will, then the controlling law would be the state where you live. And this is another reason, if you have more than one property in more than one state, you'll want a living trust. Let's go to the next slide.
What's community property? Basically, that's what you've acquired during your marriage. Very important, but in intestate succession, what happens is it gets divided. If you die and you've done nothing, basically your spouse is entitled to, depending on how many children you have, 1/3 or 1/2 of the intestate share. If there's one child, it's a half of everything in the community property and separate property. I'm sorry, community property all goes to the spouse. Separate property is 1/3 or 1/2, depending on how many children there are.
And there is also a title. You could have community property with right of survivorship as well, which probably is better than having property in joint tenancy for married couples.
So if you out there look at the deed to your house and you see that it's husband and wife, it could be John Smith and Mary Smith, comma, as joint tenancy, comma, with right of survivorship, potentially even. That means that if John dies, Mary receives the property without probate. It also means that when Mary dies, that then there will be a probate, because unless she's done a trust, that's where the probate would lie. Generally speaking, we want to plan for you both dying at the same time, because we can't assume either one of you are going to live. And hence, then we're just trying to avoid probate, and a trust does that. Now, what Pete's saying is that you could have John and Mary, comma, husband and wife as community property with right of survivorship, which does the same thing as joint tenancy. However, there's a difference in that tax lane that basically says that if it's separate property, only 1/2 of the property gets what's called an adjustment in basis to full fair market value. The other half does not. Whether if it's community property, both halves get a step up in basis to full fair market value. Now, this is really important, and maybe you just want to slow down, Jim, and talk about this. The idea is that I've had clients literally who've had property that they bought on Lido Isle, if you will, that they bought for $200,000 back in the 60s that are now worth $10 million or more. And they bought it for very small amount. When the first spouse dies, if it's joint tenancy, only half of that gets a step up in basis for capital gains purposes, which means that essentially if you sell it for $10 million 10 minutes later, your basis is $5 million plus the $100,000 of the surviving spouse, the difference is potentially a gain. And at 40% of the gain cost taxation, you're going to end up with a lot less money in your pocket. However, if it's community property with right of survivorship, guess what? Under the law, under section 1014A7, it gets an adjustment in basis to full fair market value on both halves. So if Mary sells the property after John dies and it's community property, you get, quote unquote, a double step up in basis to $10 million. If she sells it the next day for $10 million and her basis is $10 million, there's no gain.
If a married couple has their assets titled in the name of the trust, is it assumed that they own that property as community property if there's no language in the trust otherwise?
No. And so generally speaking, what you'll want is to make sure that there's either a separate document called a community property agreement that basically trumps the presumption the government's going to see if it's held as joint tenancy. It trumps that and says, oh, by the way. I love the word, oh, by the way, in most cases. Most cases I hate it, but in this case I love it. Oh, by the way, this separate document says that we didn't mean that the joint tenancy would be separate property of each of us. We instead meant that it would be community property, and hence in a good estate plan, you'll have that separate document that then allows us to rebut the presumption that it was separate property because we have a writing saying it's community property.
But let's say in a trust document, do you normally put in that we own all of our assets titled in the name of the trust? It is community property, or would it be assumed that if you have property titled in the name of the trust, that it is community property?
It's not assumed, Pete.
Not assumed. Okay. Because I want our attendees to look at their living trust to make sure that it states in there that all assets are community property.
But we have to put a little asterisk beside that.
Okay.
Because some clients are going to have separate property.
Yes.
So we don't want to say all of our property is separate property, where in fact, maybe one of the husband or wife inherited property that is considered separate property, and they want to retain that as separate property.
Yes.
Because otherwise, if you say all, that could be considered a transmutation agreement. That could cause on a divorce, that person, husband or wife, losing the opportunity to take that separate property as their separate property and not have it be divided at divorce.
So it becomes much more complicated if you have separate property, previous marriages, an inheritance, those things.
Next slide.
Are separate property. Yeah, there it is.
So community property, God spoke, I heard him. Community property is basically that which is obtained during the marriage, whereas separate property is something that you receive by inheritance or bequest, or maybe even a gift from a parent or a grandparent, or like Pete is going to give me a whole bunch of assets after this particular presentation. No, I'm kidding. Lunch maybe, but you never know.
Yeah, there you go.
So does my spouse get everything? Well, if it's a situation that it's community property and you die with community property, the spouse would get the community property absent a will or a trust that says otherwise. Okay, so if you just have community property, it's not joint tenancy, it's community property, which a lot of people have. It goes to the spouse. However, if it's separate property, then basically the rules are different. So the question is, what if I do nothing? Unless you are comfortable leaving the California probate code, the government, to decide who gets what, you better do something before you die.
Yeah, 70% of individuals do not have an estate plan. Right. So it's huge.
Right. And there's no real reason other than
procrastination.
I'll get to it later.
Yeah, procrastination is the biggest issue.
People don't like to talk about death. I'm convinced of it. And
Yeah.
there are situations where obviously people have a problem and they have to hurry into the attorney to get things done. But we've had a lot of clients we've had to say, I'm sorry, we can't help you if it's a dementia or Alzheimer's type of situations where they can't act.
Yeah.
Because the only way you can make these documents enforceable is to have what's called capacity. So if there's any question about the mental capacity of the individual signing these documents, frankly, they could be overturned.
Capacity is just a huge issue in the courts at the present time. Let's go to the next slide.
If you only make a will, what happens? Well, you get to choose who's going to act as the executor, who's going to get the assets. Again, you don't have to go through probate if you have assets that are less than 185,000, we call it. The contents and the disposition of your estate becomes public record. Okay, what happens with regard to the fees? I think I talked about this earlier. This is the statutory fee calculation. It's 4% of the first 100,000, 3% of the next 100. You start doing the math here. 2% of the next 800. So $1 million. It's what? $23,000 to the executor and $23,000 to the attorney.
And then you have all your court costs, publication costs, probate referee costs, et cetera, et cetera. For any kind of substantial estate, you want to avoid the probate. Is there anything good about the probate?
The answer is it depends. Again, it depends. I mean, if you have a family that's just off the charts contentious, in other words, you know they're going to fight, and I've never had that to the degree that I would recommend probate. But if there was such a thing in life, it depends, then maybe you want to go through the court.
And have a judge there.
You have a judge there to keep them from killing each other.
Yeah. How about debts? If you have a lot of debts.
If you have a lot of debts, then essentially probate is probably not the place you want to be, because if you have all your assets in the probate estate, you must, by law,
inform the creditors.
Tell those creditors that they have a right to come in and contest the will or contest the distribution and receive a creditor's claim protection.
And what do they have? 3 months or 4 months? I can't remember.
4 months.
4 months. Let's go to the next slide. We need to get into a trust.
Okay, so the idea behind a trust is, if you think about it, what you're doing is you're taking it out of your right hand, which is your ownership hand, and you're putting it in a box called a trust. The basic issue there is you're avoiding probate by assets that you transfer from your hand, because you can sign your name, and putting it in the trust that now owns it. So you don't own it, your trust owns it. But the good news is you, as the settlor of the trust, can change the trust. It's revocable or amendable. You, as the trustee, are generally going to be the trustee during your life or your capacity. And thirdly, you're going to be the beneficiary. So over here, when you owned it, you basically managed and controlled and used and enjoy your assets. They're yours. The downside is if you die, it has to go through probate. Whereas if you can sign your name and transfer those same assets into the trust, you still manage and control because you're the trustee, and you use and enjoy because you're the beneficiary. And believe me, you're not going to have schizophrenic conversations. Can I use my money? Yes, I can't. You're not going to do that. It's basically just a vessel. It's a kind of a game we're playing to transfer title so that it doesn't have to go through probate.
Yeah, you don't even have to change your social security number.
Well, it's called a grantor trust, and under the code, basically it's your social security number for that particular trust until you die. That's when things change.
Yeah, but there is a cost and to administrate. And when we talk about administrate, that is somebody stepping in upon incapacity or death.
Right. Yeah, it literally, if I'm dead and I'm the trustee of my trust, I can't act. And if I haven't named somebody in the trust to take over as what we call the successor trustee, then what has to happen, God forbid, is we have to go to court and wait in line to get a trustee appointed to manage my trust. Now, generally, if it's husband and wife, if husband dies, wife continues to act as trustee. But you have to ask the question, is wife or husband, whoever the successor is, capable at that point, based on age, acuity, all those things, are they able to do that? And hence, if they can't, you still need a successor trustee who's like a third party. And Pete can talk about that if he'd like.
Yeah, we're going to have a total session on trust administration in session number 6. But the idea of as to who to name as a successor, really, you need to really open up and speak to the attorney. I would imagine, Jim, your conversation as to who's going to be the successor trustee does take some time with the client.
It does, and it's not always intuitive that who you name. In fact, in most cases, clients come in with a preconception that they're just going to name their oldest child or their smartest child or their most educated child. And the reality is that we like to create what's called a common enemy. In other words, if there's any appearance of dissension within the ranks of the children, that's going to basically be put on fire when mom and dad die. And then one who gets power can use it in a way that basically destroys potentially the relationship with the other siblings. So if we have a common enemy, a third person acting, they get at least one thing in common. They could hate each other, but bottom line is they're going to look at the trustee and say, how quickly can you get this done? And hence they have one thing in common. It's not being done quick enough. Yeah. Now, reality is it does take time. Pete can tell you this. It does take time. Everybody thinks that when a person dies because you have a trust, that it's immediate. It is not immediate. It can take 9 to 18 months.
People think that I'm kidding when I tell them you're lying about having a common enemy keeps the family together. Yeah. All right, let's go to the next slide.
So the settlor is you. You're the one who's basically drafting the trust with us using the words to describe what you want. You choose who are the successor trustees. You decide who's going to be the remainder beneficiaries, and you basically have to fund the trust. Now, attorneys, generally speaking, in my experience, at least in our practice, we help you fund the real estate. We help you fund the personal property. We may even help you fund business interests such as corporate stock or partnerships or LLCs. We will help you do that. But it's going to be up to you to take this certificate of trust down to the bank or the investment advisor and make sure that the title is changed from your names to your names as trustees of the trust.
Give me an example title for a trustee, for a trust.
Jim Leese, trustee of the Leese Family Trust, dated January 1st, 1997.
There you go. Where can people find if they can't remember how their assets are titled, like real property, what would they look at, or where would they go?
They would go to the trust instrument itself. If they can't find the trust instrument, then potentially they go to title and try to figure out from the actual address and maybe the APN number what the title to the trust was.
Yeah, property tax would have the proper title on the property tax form.
Generally, not the full title. No, it's just
not the full title.
Trustee is. It's not going to say what the trust is.
And that's called trust funding. This is so important. Talk a little bit about that.
Well, again, if you have assets on this side that would otherwise go through probate, and you don't transfer them into the trust that avoids probate, you've got these assets over here that may have to go through probate to get transferred to the trust. So what we do is we don't take into consideration that you're going to do it perfectly. Okay, because that's not going to happen potentially. So I used to use this as my example when I taught at UCI. I don't play the lottery. Why don't I play the lottery? Well, because I know that I'm going to win the jackpot, and I'm going to have that winning lottery hand in my ticket, and I'm going to walk outside of the 7-Eleven and get hit by a bus. And so I'm going to have a $20 million lottery ticket in my hand, and all my other assets are in the trust. But how does it get from my greedy little hand with the winning lottery ticket into the trust? Now, no one's going to pry it out of my hand except maybe my executor, who takes it and has to go through probate to put it into my trust. Okay, so that's what we're trying to avoid. And essentially, other documents that we provide with regard to the estate plan, called the statutory form power of attorney, could name the agent to pry it out of my hand and put it in the trust. But absent all of these pieces to the grand scheme puzzle of the estate plan, it may not happen. And hence, that pour rule is very important, because it becomes basically the instrument by which the trust gets funded if I forget to put something in the trust when I die.
So in a will, you have a section of distribution. And in that distribution section, you state all my assets go to my Jim Leese family trust.
Correct.
And that's called the pour over provision. And so most of us will have a pour over will in the event we have a winning ticket that is in our own name and titled in our own name, and it's not in the name of the trust.
Okay, here comes the voice of God. Number one, Jim, I'm going to point out the fact that if you win a lottery, the odds are not $20 million anymore. Clearly, you have not played recently. It's 1.4 billion this week. So we'll do that one from an age standpoint. The other question really is, so I put all of my assets in here?
So qualified assets like IRAs, 401ks, 403bs, they can't go into a trust, primarily because the Internal Revenue Code disallows that.
Has to be a person.
Yeah, but you could if you wanted to, and then this requires conversation. Okay, it's a depends type of thing. You could, under the right circumstances, name the trust as the beneficiary of the plan. It's going to basically be a conversation you have with the attorney, potentially with a CPA and an investment advisor, as to whether you want to name the trust as the beneficiary.
We're going to have an entire
or a beneficiary designation outside of the trust.
Into it now.
And yes, we have an entire section on retirement plans. So what do I do with my car?
Your car, depending on if it's
not the 57 Thunderbird.
If it's a Bugatti, you want it in the trust. If it's a 57 Thunderbird, you might want to put it in the trust as well, just to make sure that it goes to the people you want it to go to. Because if it's in your name, pretty much anybody can go to the DMV or to AAA and say, "Hey, it's mine," and get it.
Here's my death certificate.
Regular car.
Okay, you leave it out. Do I have a checking account inside and outside?
Hang on, Don. For a regular car, what should you do?
It's not a great deal of effort to go across the street to AAA and change it to the trust if it's valuable. If it's not, then you don't have to, because a small estate affidavit will avoid probate, assuming other assets in the estate are not more than $185,000.
And I find that the DMV and the auto club will handle the transfer of a car very easily. And for a married couple, or if you may want to put or Jim or Pete Leese as a
didn't know that, Pete.
Wow.
Yeah.
So, that was a leap.
If one dies, the other one has the title. It's not a big deal. Don, you had another question?
So are all these trusts we're talking about revocable? Can I change it during my lifetime and capability?
So during your lifetime, Don, you can, because there's a provision in the trust that allows you to terminate, amend, or change the trust at any point in time, if you have the capacity to do so.
Right. So now 5 years later, I go, oh, shoot, I want to change my trust. Do I have to retitle everything?
No, you don't.
Thank you.
We typically, I mean, I've been around long enough where seen people amend and restate their trusts 7 times. And so we're in the 7th version of the original trust that then basically supersedes all previous versions.
Yeah.
And it's because of lots of different circumstances that happen within the family over a lifetime.
What is the difference between a restatement and an amendment?
An amendment simply is taking a certain provision of the trust, the full trust, and changing it. So, for example, in our practice, we like to do amendments and restatements if there's more than 1 or 2 amendments. The idea being is you've got this whole set of instructions in your regular trust, but if you just want to tweak 1 or 2 things, like change the trustee or change the provisions with regard to some tax, we might do just an amendment of that. But once we do several amendments of that trust, it becomes the possibility of ambiguity, and the possibility of ambiguity leads to probate court to resolve the ambiguity. And it's better to just do an amendment and restatement of the trust that has everything in one place, so nobody's having to construe how all of this changed over time.
You want to keep it as simple as possible so everybody understands it.
Right.
Having a ton of amendments gets everybody confused because it starts reading like the IRS code. And that's not what you want to have happen to your trust.
No. And this is a perfect time for those of you who are listening who've done trusts in the past, especially 10 years ago, and you haven't revisited them, or you have tax language within your trust that's really antiquated today. Old trusts basically that were done prior to 2011 should be reviewed by an attorney to tell you what the new laws say with regard to the ability to port interest for estate tax purposes.
Party trust. Talk a little bit about a trustee, but just remember we have a whole session on trust administration.
Well, I think we talked about it. The trustee's just manager.
How about what's the definition of a fiduciary?
Somebody who has an obligation to the beneficiaries to do the right thing.
Does a family member have a fiduciary duty or different than a professional?
No. I mean, if I name my son John to be the trustee of my trust, he's held to the standard of a corporate trustee, which is a very high standard. Every fiduciary has that same standard. So he can't say, oh, I didn't know. No, he can't say that and avoid liability.
And anyone can be a trustee after the age of 18?
Correct.
Okay.
Well, let me again, it depends. If they're disabled, probably not. You know, because they don't have the capacity. So essentially, what you're looking for in somebody who is a trustee are maybe individuals, private professional fiduciaries, or a trust company. Those are really your 3 major ones. You wouldn't want your attorney to be your fiduciary.
No.
That's a conflict of interest, and we won't do that.
And I would caution you to name friends. Just they don't want to say no because they love you and care about you. But if they've not done it before, gosh, you're throwing them into a rat's nest, especially if there's any dissension amongst your kids.
Yeah, Pete, I oftentimes, even still now today, when one of my clients passes away and I'm meeting with the family to talk about what the trust says, it's not like in the picture shows, if you will, or the movies where you sit down and you wear a cape and all that. It's not that.
The movie.
No, it's not, a wonderful life. It's basically sitting down with the family and listening to their questions, kind of consoling them to the degree that we console them, and then telling them what's going to happen. And generally speaking, when a husband or wife or mom or dad dies, I recommend that they really consider using a neutral third party whether it be a professional fiduciary or a trust company, to manage the estate. And I start off by saying this: you've been named as the trustee, i.e. the fiduciary for the trust. I recommend that you run, don't walk away from that position, because it's subject to liability. And you may not know that you've done something wrong because you aren't asking the right questions. We oftentimes find in situations where that happens, where they've named an individual, that they do things and then they call the attorney and say, oh, by the way, I just did this. And then the attorney says, no, you shouldn't have done that. And hopefully we can fix it, but sometimes we can't. And that creates personal liability for the fiduciary for any losses or damages associated with their activities.
And we're going to learn more on that in session 6. Let's go to the next slide.
So who are beneficiaries? Generally, those are your loved ones, or maybe it could be a charity, or it could be, if you don't have children or you don't like charity, maybe it's your best friends or whoever you think would be the natural object of your bounty. I love that word. Those are the people that you would be naming as the beneficiaries. Now, the question is it an outright distribution, or is it going to be held in trust for that person? Now, mind you, if you don't do a trust and you don't state it, a young person, a 5-year-old person who maybe has $5 million or even $1 million in their estate, or their guardianship, or maybe it's a 401k or whatever, they're going to inherit that at age 18. And few 18-year-olds are going to be able to manage money in a very good way. In fact, they're probably going to waste it. A trust allows you to hold it in trust for the benefit of the beneficiary, as opposed to an outright distribution at age 18, or for that matter, 35, if it's a person who can't handle money. You could keep it in trust. You could have a third party, i.e. a fiduciary such as a corporation or a professional fiduciary, manage it for that beneficiary for lifetime if you want. In fact, that's what we oftentimes recommend.
And so for us, when you say a distribution and trust, for example, would that be somebody who's on government benefits, a special needs trust?
So Pete mentioned, I think that I have a child who has autism. Dylan's probably, God willing, maybe probably will never be able to manage his own estate. And so we want to protect him. We also have concerns about his benefits. In other words, children with autism who aren't able to take care of themselves, or for that matter, any other disability, might qualify for Medi-Cal or Medicaid in other states. They might qualify for SSI or SSDI or any other government programs that are out there to help disabled children. We would want to devise the trust. In fact, every trust I've drafted since Dylan's diagnosis has included a special needs trust, just in case a child has a child that has a disability and that child dies, and it goes to the grandchildren as a natural inheritance under the terms of the trust.
And you could even do a special trust, not called a special needs trust, but maybe a spendthrift trust for somebody who likes Nordstrom's a little bit too much. You can do a special trust for somebody who maybe has an alcohol or a drug problem.
Yeah. And Pete, what we're doing is we're looking down the rabbit hole far enough to try to take into consideration that maybe it's not your child that has this problem, but if we do a trust and your child isn't alive when you die, which is possible, you'd be in the same car accident, then it goes to the grandchild, and we don't know what's going to happen with that grandchild 20 years from now or 10 years from now. But if in fact they have one of these problems, i.e. a disability, we already have built into the document, the trust, a provision that protects them and preserves their government benefits.
What about somebody who may have a bankruptcy issue, or maybe has a marriage issue that likely on the horizon, you see a possibility as a divorce?
Right.
What do you do? What kind of trust are those?
Well, those are irrevocable trusts for the benefit of the beneficiary. They're irrevocable, which means it can't be changed. It has provisions called spendthrift provisions in them. I like your use of the word spendthrift. It basically says this: if I give my child money outright, they now own it. And it's likely that if they marry the wrong person, we call that person a predator. If they marry the wrong person and they basically commingle it with that person as like in a bank account or in a house or whatever asset they buy, then on divorce, they may lose half of that, if not more. Whereas if it's in a trust, technically, legally, the irrevocable trust over here is not owned by them. They don't own it. And so if there's ever a divorce, the predator, if you will, is not going to be able to receive the benefits of this trust. Now, there's a case that just came out a couple of days ago back east, where because of the way the trust was drafted, the spouse did get the benefits of some of the trust. And so what we know is in this society, it's never perfect. But unless we have it, we don't have at least the opportunity. California still has the law that says it's protected, but we don't know what's going to happen in the future. But still, it's going to benefit that person, that beneficiary who has a drug problem or has an alcohol problem or whatever problem, special needs. This trust is going to protect it.
Yeah. One of the things that it's becoming quite common, and we have talked about this in the past, Jim, is that the female spouse dies, the male spouse is alive. All of a sudden he meets that wonderful real estate agent when he's 85, and is there anything you can do regarding that to prevent the passing of the 85-year-old estate going to the younger new potential spouse?
Yeah, this Pete must have remembered this because this was a real life story that happened to me probably now 15 years ago, Pete. But I had an 82-year-old gentleman driven to my office by his new 48-year-old wife, who was his real estate broker. And hopefully she's not listening. But the reality was that she was driving him to my office because his wife of 53 years had died literally 5 months earlier. And she was driving him to my office with the intention, I believe, to have him change everything to give everything in his estate when he died to her. Now, thankfully, we were able to do some planning so that he could benefit her, but when he died, it would go to his kids. And so that's using irrevocable trusts. I got 5, at least 6 different versions of that story that I can tell you or bore you with, but none of it can be made up. It's exactly as it sounds. It is a predator, and they're out there, and be careful. Even though we don't want you to live in fear, there's a situation where we need to be aware of and protect and provide for that. And it's possible with irrevocable trusts.
My mother firmly believed that they had to have an AB trust. And so that's how they were dealing with some of these issues, except that she believed that AB stood for anti-bimbo. And she was adamant, not above, not below, which AB, the other side of the argument, is hers was anti-bimbo.
I think the important part is that when you go into an attorney's office, you literally have to open up and talk about your fears, talk about what's happening in your life. It's not uncommon here in Orange County to have second, third, and even fourth marriages. It gets complicated. And unless you kind of talk through all of these issues, you're not going to have a good estate plan. And that is the difference between a trust mill that has 70 pages boilerplate versus going to somebody like Jim or some of our other presenters. They listen to you and understand the issues and then design the trust based upon your family needs. Phases of a trust. Talk about that. We have about 10 minutes left.
Okay, so So we've got during the person's life, it's basically the individual who's created the trust as a settlor, the trustee, and the beneficiary. But what happens during incapacity? During incapacity, that's this stage down here. During incapacity, someone else has to take over and manage the trust. That's called the successor trustee. And then finally, then there's the death of the settlor. So if an individual, if I, Jim Leese, so the trustee of my trust, I'm over here, I basically can manage my own trust. I really see no difference other than instead of my right pocket, it's in my left pocket. And essentially I'm managing and controlling it, using, enjoying it, and I'm not questioning myself. But when I become incapacitated, guess what? I don't want to have to pretend I know who's going to take over. I want to specifically name an individual, a professional fiduciary, or a corporation to take over and manage it for me so that I don't get into a situation where I don't have my needs taken care of.
Yeah.
Now, if I don't have a trust, then it's possible without a power of attorney that's specific enough that we'll have to go get a conservator appointed for me to manage my estate. And Pete can tell you that's a nightmare.
Yeah.
That's
yeah.
a
A living trust can pretty much avoid a conservatorship. Again, it's not 100% ironclad, but it goes a long way to avoid a conservatorship during your lifetime. And this is all about life. This is, I mean, we normally think about estate planning as death planning.
Yeah. Look, it's only 1/3 of the.
Yeah. Capacity. Who's going to be taking care of you? Where does the trustee live? Are they, do they have time for you? Lots of good issues that you need to talk over with your potential trustee. Let's go to the next slide.
So these are basically, you can read these, but basically it's just a statement of intent as to what you're going to do with your assets. It governs the administration during incapacity. It governs administration after death. And then finally, it governs the administration for the beneficiaries. So it's doing everything within one document that would otherwise take several documents to accomplish. So this is basically a one size fits all in terms of planning. It's talking about chapter 1 while you're alive, chapter 2 when you become incapacitated, chapter 3 when you die. And within chapter 3, it says who's getting what, when, where, and how.
It's like a contract.
It
And
is a contract.
it carries out that contract, your wishes. Do people ever come up to you afterwards and say, Mom told me?
Do they ever, or when do they don't? Is that what you're asking?
Yeah, kind of.
Yeah, they say Mom told me, and I point to this section.
Right to the trust box.
Yeah, well, that's not what Mom said.
Yeah,
it's in writing.
Yeah. What is trust administration anyway? I love your title.
It's basically a way for the settlor as trustee to manage his affairs or her affairs without really any need to go to court to have somebody step in on a moment's notice and protect the trust.
Yeah. When you're alive and you're your own trustee and your own settler, do anything you want. It's your stuff. You don't have to ask anyone else permission. So
at this point, Pete, we typically, if we were in a room full of people, we would say how many people have trusts, and they would ask them, what was the last time you looked at the title to your house? And we would say, if you haven't looked at the title to your house, you need to go look at the title to your house to make sure it's in your trust. Why? Because if it's not, it's going to go through probate to be put in your trust.
Look at all the assets you own and look at title.
Exactly. And I'll tell you, during the first part of the 2000s, we had these people basically taking their house out of trust to refinance the home. And they do that maybe several times. And we found on several occasions where they forgot to put it back in the trust following the refinance loan.
And then for their asset was named in their own names,
exactly.
Therefore kicking into probate. and it's the gross value of the home,
Yeah.
your net. Successor as trustee,
That's where I'm unable to manage. I name somebody to take over. It's really that simple.
yeah, and it's easy because the person just steps in and manages the assets.
Right. So this is an illustration of the phases I was describing before for a single person. Basically, it's during your life, you're in control. There's no difference except title.
Oh, if you're a single person, please have a living trust, because at least if you're married, your spouse can help you if you have an incapacity issue. Much better if you're single, you just don't have anyone who has the legal authority to act on your behalf.
So then once you become incapacitated, that's a period of time where you have somebody else helping you. And generally that's somebody you trust. And again, we talked about who should be the trustee, and Pete's going to talk about later in a different session about that issue. After death, there's an administration period. And generally that's 9 to 18 months. It could be longer depending on the assets, could be longer if there's disputes within the trust. And then finally, there's the distributions to the
yeah, this is the key.
So in planning, and I don't know how much time we have to go.
Yeah, 5 minutes.
Okay, so here's the key. You've got Harold and Harriet. They own a joint trust. Harold dies. He's the deceased spouse over here. Now, what could happen is the entire trust could go into the survivor's share, which is called Trust A. But what's the problem with that, Pete?
It's in total control. If you have a second marriage, there could be an issue. If you have a $50 million estate, it could be a major problem because you didn't take advantage of the estate exemption. Lots of issues.
Predators and creditors.
Yeah.
They're just waiting for that to happen. They're drooling. Okay. So what happens if instead you put Harold's share in a trust? That trust is irrevocable. What happens at that point is you build a wall between the two estates. It's as if you've got a wall here that protects this side from this side. Now, the good news is that generally speaking, the surviving spouse has the right to use the property, but these people over here can't get through the wall. So it's a way to protect the assets in these trusts. Okay. So that's the basic idea. Now, I'm telling clients all the time now, be careful. If you do this, you're not going to like me very much, because you're going to come back in and say, why did we have to create a subtrust? I don't understand. Well, bottom line is, because we had the conversation and you chose that if one of you died, you'd want to protect this spouse's interest to go to the children after you die. In the meantime, you can use it, you can enjoy it, you can even manage and control it, but these people can't come through the barrier and take it from you. That's why you did it. Yeah, but there's always a but. Some are bigger than others. In this one, it's a big but. But I recommend that if anybody out there has told you that it's easy when a spouse dies and they have these separate, what we call subtrusts, they're lying to you. And I don't want you to go through the point where you don't understand that.
You want to keep it as simple as possible unless it's needed.
Right.
Okay, let's there's your address. Why don't you end your share and let's all come on the screen. By the way, Trevor Murphy is on the screen as well. Trevor, you're more than welcome to come on. Since you are the president of Financial and Estate Literacy. Donna, you want to come back on the screen? And our philanthropic advisor, moderator, and hey, there you go.
I'll comb my hair if you want, Trevor.
Try to comb my hair.
Yeah, mine isn't much.
We should have anybody under 50 on the screen.
Oh, we're all gonna. Anyway.
Are there any questions, Don, or issues that you think that we need to bring up?
Nope.
We've got a few minutes.
We've done a good job of going through and doing that. So
How about you, Trevor? Do you have any issues that you see that we kind of skipped over in your experience of being a professional trustee?
No, you guys done a great job.
Geez, Jim.
I didn't wear out my welcome. Is that what you're saying?
Not at all.
Whatever, experience has its place. I've just enjoyed your session, Jim, and I'll always learn something new. One of the things that I usually in the olden days, we just use an A-B trust almost exclusively. What does that C trust that you showed on your slide, what does that mean?
So in the olden days, prior to 2011, we had a concern about basically using what's the deceased spouse's applicable exclusion amount for estate tax purposes. In other words, we had to put that credit, if you will, into a separate trust to preserve it so that when the survivor died, you basically didn't have to tax this amount at that person's death. Now in 2011, the law changed. It said, no, you don't have to put it into a separate trust to preserve the credit. We're going to let you to elect to port, if you will, it's called portability, this share over into the survivor's name. So then it doubles up whatever credit that the survivor had.
Okay.
But we want to create a trust that's protected. So how do we do that? We put it in something called a marital trust, and it's called a Clayton election trust.
Okay, so the C trust is usually called the marital trust, but it can go by other names, right?
Q-tip trust is the normal provision that you want to use. It could be a general power of appointment trust. It could be an estate trust. The Q-tip trust is
the purpose of it is to keep that trust separate, protect its spouse, and also that C trust gets what's called the step up in basis upon the.
Correct. Because what we know is that we've used the portability section of the code to add to the surviving spouse's code. And hence, when that marital trust ends, what we know about a marital trust, it's taxable at the death of the surviving spouse. So yeah, we're taxing it, but we've doubled up the credit, so we should cover as much as we can in terms of estate tax purposes.
So in the interest of time, what I'm going to say is, this is financial and estate literacy. We're doing It's Your Estate. Next week, we will be talking about retirement planning. And Jim, I thank you very much. Trevor, I thank you very much for remaining silent and not visible. Pete, it's been fun, and I'm going to turn off